everyone, Ashley Aarons here, Client Services Director with the Rocky Mountain Victim Law Center for our third of 5 videos regarding the Victims' Rights Act. In the first and second video, we talked a little bit about the history of the VRA and then also the foundational aspect of fairness, dignity, and respect to all other rights that an individual might be afforded under the VRA. Today we're going to focus on the right to be informed and notified of critical case changes, of upcoming court dates, opportunities to exercise your rights under the VRA. Oftentimes when we talk about the right to be informed, we're talking about letters you might get in the mail, phone calls you might get from law enforcement or from the DA's office, or post-sentencing options like parole or probation. We really like to frame, if you're not reading the entire VRA, we like to frame the idea of notification and information around critical changes that might happen in your case that you should know about. In the spirit of the VRA, that's going to be from little things to big things, but with an emphasis on those critical case stages. If there's a change in the status of the investigation, that's a great example of a time when you are afforded a right to know and understand what's going on. Alternatively to that, you don't have a right to know if the case has remained the same. We see this a lot in cases where there's a long investigation period. You may not be getting weekly or even monthly updates from law enforcement about the change or investigative process that's happening in your case, but should anything change, you are entitled to notification. After a case proceeds and is heading towards trial, you should also be getting notified about upcoming court dates and the rights that might happen at those. In our office, we get the opportunity to work with many folks who share the letters they receive from DA's offices about upcoming court dates, and oftentimes those communications can include information about what might happen at the hearing, as well as if you're going to have the opportunity to be heard. Many times these types of notifications might happen over the phone in conversation with a victim advocate or a DA, a district attorney. These communications can also provide additional information about your obligations at those hearings. These rights that you're entitled to around notification or even the right to be present or to be heard are just that. They're rights, they're not obligations. And the more information you have, in our opinion as RMVLC, the better you are to engage with the process, which is one of the fundamental reasons that the VRA was formed, is the deep belief that victims should have the opportunity to know what's going on so that they can make decisions about their own engagement with the criminal justice system. As you are navigating a case that's walking through the criminal justice system, we hope that you're getting the notification that you deserve around upcoming court dates, expectations, as well as changes in status. If you have any questions about that right, or would like to learn more about that, please consider visiting our LINK, Legal Information Network of Colorado website. You can find the link to that LINK website in the description of this video. Thank you so much. I look forward to talking to you in 2 weeks about the right to be present, followed by our final video, our 5th video, about the right to be heard.